meeting to order. Welcome to meeting number 24 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of February 2nd, 2026, the committee is meeting to continue its study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters, child protection, gender-based violence, delays, and other measures. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I'd like to confirm that the sound tests were made successfully. Yes, okay. Before we continue, I would ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, including the interpreters. You will also notice a QR code on the card which links to a short awareness video. I'd like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. For those on Zoom, at the bottom of your screen, you can select the appropriate channel for interpretation, either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For the members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can. And we appreciate your patience and understanding in this regard. So welcome to our first panel of witnesses. In the first hour, we have from the Canadian Centre for Child Protection, Monique Saint-Germain, General Counsel. From Daughter Protect Canada, we have Christine Szabo, Advocacy Lead. And from the London Abused Women's Centre, we have Jennifer Dunn, Executive Director. So the floor is open to the three groups. Each of you will have up to 5 minutes to make opening remarks. Following the conclusion of all of the opening remarks, I'll open the floor to questions. So since Ms. Dunn, since you're to my immediate left on the screen, I'll start with you.
Thank you for the opportunity to appear before you today. My name is Jennifer Dunn, and I am the Executive Director of the London Abused Women's Centre here in London, Ontario. For over 4 decades, our organization has supported women and girls subjected to male violence, including intimate partner violence, sexual exploitation, and trafficking, with long-term counseling, advocacy, and support. With my time today, I will focus on the proposed amendments related to femicide and the proposed criminalization of coercive and controlling conduct within Bill C-16. The London Abused Women's Centre welcomes recognition of femicide within this legislation. Treating murders that occur in the context of control, hate, sexual violence, or exploitation as the most serious form of homicide, and naming femicide as a distinct form of violence is important. It acknowledges what frontline organizations like ours, researchers, and families have long known, that violence against women is gendered, patterned, and deeply rooted in inequality. Recognizing femicide helps make visible the realities that too often go unnamed. However, it's important to be clear. Naming femicide alone will not prevent it. While recognition is meaningful, it must be accompanied by sustained investment in prevention to address the root causes of male violence against women and the systemic barriers that women face. Without that, we risk creating language without impact. I would now like to turn to the proposed new offense of coercive and controlling conduct. The London Abused Women's Centre agrees that coercive control is real, dangerous, and often precedes lethal violence. It is a critical concept in understanding how abuse operates over time. However, we have serious concerns about the risks of criminalizing coercive control in the system as it currently operates. I urge you to consider the reality of mandatory charge policies in intimate partner violence cases, for example. In May 1981, the London Police Service became the first police force in Canada to institute a mandatory charging policy for intimate partner violence cases. These policies were intended to relieve victims, most often women, of the responsibility of deciding whether their partner should be charged to increase their safety. Police were directed to lay charges where there were reasonable probable grounds. Introducing a new, highly nuanced criminal offense without addressing these systemic issues risks widening that harm. Police officers responding to intimate partner violence calls are often making decisions in highly volatile, time-limited situations. It is not possible to have a full picture of an intimate partner relationship when responding to an emergency call. There is a real and growing risk that survivors, particularly those who are seen to resist, defend themselves, or present themselves as less ideal victims, could be misidentified and criminalized. If this offense proceeds, it cannot stand alone. Coercive control is a deeply nuanced concept. Its identification requires an understanding of power, gender, trauma, and systemic bias. We have seen this in other areas, such as judicial education on sexual assault. The training cannot and should not ever be optional. We cannot afford to repeat that gap. There must be mandatory, ongoing, and accountable training for police, Crown attorneys, and judges. This training must include coercive control and trauma and violence-informed practice. Without it, the law risks being applied unevenly and unjustly. Finally, I want to emphasize what we know to be true. Criminal law on its own does not prevent violence. As highlighted in the brief by the Barbara Schleifer Commemorative Clinic and LEAF, criminalizing coercive control does not address the underlying causes of violence against women, nor the barriers that prevent survivors from reporting. We know what does help prevent violence. In London, our high-risk action table for femicide prevention brings together police, community agencies, and service providers to identify and intervene in the highest risk cases before lethal violence occurs. This kind of coordinated multi-sector response allows for a fuller picture of risk, something no single system, including policing, can achieve on its own. If we are serious about ending violence, we must invest in these coordinated preventative models alongside early intervention, long-term advocacy and support for survivors, housing, and guaranteed livable income. In closing, we support efforts to better recognize and respond to the realities of violence against women, including femicide and coercive control, and this is a significant step forward. Legislation must be grounded in the lived realities of survivors and the systems that respond to them. Without careful implementation, safeguards, and investments, there is a risk that these changes could unintentionally cause further harm to the very women they are intended to protect. We cannot afford to get this wrong. Thank you.
Thank you. Right on time. Ms. St. Germain, over to you.
Thank you, Mr. Chair Maloney, and to this committee for inviting our agency to participate in this study. My name is Monique St. Germain, and I am General Counsel for the Canadian Centre for Child Protection, a national charity that works across Canada and globally to reduce the incidence of missing and sexually exploited children. We operate cybertip.ca, Canada's tip line for reporting the online sexual exploitation of children. As of March 31st, 2025, nearly 471,000 reports have been processed through CyberTip. Reports overwhelmingly pertain either to child sexual abuse and exploitation material or online luring. We also operate Project Arachnid, a platform that prioritizes the removal of harmful child sexual abuse content online. As of this month, Project Arachnid has issued over 141 million notices requesting the removal of CSAM from the internet. We support the changes in Bill C-16 that are aimed at protecting children and victims of image-based abuse, including the following. First, the expansion of the luring offense to include luring to facilitate extortion, criminalizing threats to distribute CSAM and intimate images, and the addition of sextortion as an aggravating factor on sentencing are all great additions to the arsenal of available tools in the criminal code to address sextortion. Over the past decade, sextortion offenses have skyrocketed. On average, CyberTip receives 6 sextortion reports per day, and in 2024 alone, our support services department managed nearly 2,800 requests from children and their caregivers. In our experience, boys are typically extorted for money, while girls are extorted for more images. Tactics used can be very extreme and terrifying for the young person. In some tragic instances, the young people threatened feel so helpless and trapped that they have died by suicide. This is an incredibly serious crime, and we are confident these new provisions will help. Second, increasing the age of those protected by Section 161 prevention orders from age 16 to age 18. A Section 161 order is only available to a court once a person has been convicted of certain sexual offenses. By adding to the offenses for which such an order is available and increasing the age of children able to be protected by such orders, we are providing courts with a powerful tool to prevent future offending. This change is one our agency has long advocated for, and we feel strongly that it will make a tangible difference in protecting children from predatory conduct. Third, we support the changes to the mandatory reporting legislation, clarifying who is bound by the law, increasing the preservation requirement, and the new requirement for transmission data to be sent to police are all critical improvements to the law. Fourth, we're pleased to see the addition of a safety valve to reestablish mandatory minimum sentences into the code. It has been incredibly disheartening to witness the dismantling of these sentences on the basis of hypotheticals. We regularly monitor Canadian case law, and it's clear that the extent of offending against children is getting much worse. Most offenders we see before the courts have inflicted grave harm on victims and society, yet the seriousness of their crimes are downplayed when the focus turns to hypothetical offenses and offenders. We are cautiously optimistic Bill C-16's changes will lead to more meaningful sentences that tie directly to the offender before the court and the actual offense that the offender committed. Fifth, while we welcome the changes to address sexual deepfakes, we also want to see the creation of this imagery addressed. CyberTip processed 9,000 sexually explicit AI-generated images and videos of children and youth in 2024. The problem is harming more and more Canadians, and it has to stop. It is the creation of this imagery that first violates the victim's privacy and sexual integrity. It's the creation that starts the chain of victimization. These images are also a powerful silencer of women and girls. They are not harmless products of the imagination. Finally, while we are pleased to see distribution of bestiality imagery criminalized, we would like to see the law go further and also criminalize the making, possession, and accessing of such materials. In closing, while we support Bill C-16, we and the survivors we support also want to see Canada enact laws that hold online companies accountable, that mandate the swift removal of CSAM and intimate images, and that provide better, more accessible remedies for victims of such crimes. Thank you.
Thank you very much. And over to you, Ms. Szabo.
Good afternoon, committee members. It is an honor for me to appear before you today. Daughter Project Canada is a Canadian nonprofit organization working to end the sexual exploitation of children and youth through awareness, prevention, and advocacy. As a national organization, our work is informed by direct engagement with communities across Canada and by the growing realities of online harm facing Canadian children. Daughter Project's publicly available resources, including the Sextortion Safety Guide, were developed in response to demonstrated need from Canadian families. Daughter Project Canada supports the intent of Bill C-16. We welcome recognition of harms such as coercive control, online sexual exploitation, and technology-facilitated abuse, particularly as they affect children and youth. It is our view that any Canadian child accessing the internet can quickly become at risk. With this in mind, Daughter Project has made 2 recommendations for amendments to Bill C-16 and 2 recommendations around implementation if it is passed. Firstly, strengthen the definition of intimate image to reflect a harm reduction standard. We recommend that the definition of intimate image in Bill C-16 be amended to replace the current standard, likely to be mistaken for a visual recording of that person, with the following: that is presented or capable of being presented as a visual recording of that person. We submit that the harm of a sexualized deepfake or non-consensual intimate image does not depend on how convincing it is. The harm lies in its creation, potential distribution, and its impact on the dignity and well-being of the person depicted. Secondly, address online exploitation through shared responsibility, not only criminal penalties. Children are being exploited online in environments designed for engagement and addiction, not safety. Effective prevention requires shared responsibility, individuals, platforms, communities, and governments. Individual accountability is essential, but systems shape risk. Criminalizing conduct after images are created or shared does not stop initial harm. Therefore, rapid takedown mechanisms, platform accountability, and digital literacy education are essential complements to the law. If the bill is passed, we recommend that criminal offenses are paired with mandatory national prevention. Our mandate focuses on preventing exploitation before a child is harmed. Our concern is ensuring that laws do not unintentionally place victims, especially young people, in greater danger or discourage disclosure of abuse. Children and youth who experience exploitation often require years of trauma-informed counseling and supports such as stable housing and family connections. Without sustained investment, we risk seeing survivors cycle back into vulnerability even after their abusers have been convicted. Root causes such as harmful gender norms, online normalization of sexual exploitation, lack of digital safety education, and economic vulnerability are not addressed through criminal offenses alone. Addressing these requires prevention strategies alongside legislation. Lastly, mandate national data collection and public reporting on child sexual exploitation. Daughter Project Canada recommends the introduction of statutory obligations to collect standardized national data on child sexual exploitation and technology-facilitated abuse, and to publicly report on trends, prosecution outcomes, and prevention gaps. Bill C-16 defines and criminalizes new forms of exploitation, but does not require systematic data collection or reporting. Other organizations appearing before this committee have highlighted that a lack of data undermines both prevention efforts and accountability. In closing, Canada cannot arrest its way out of child exploitation. If Parliament recognizes new harms, it must also invest in stopping those harms before a child becomes a victim. Prevention reduces victimization upstream of the judicial system. Education for parents, caregivers, educators, and communities, especially around online grooming and coercive behavior, is one of the most effective ways to reduce demand for criminal justice intervention. I thank the Chair and committee members for your commitment to the safety of Canadian children and youth represented in this bill.
Thank you very much. Okay, we'll start the first round of questions, which are 6 minutes each, starting with Mr. Lawton.
Thank you, Chair, and thank you all witnesses for your time today. I'd like to start with you, Ms. Dunn, and just by way of disclosure, I'll share my wife sits on the board of the London Abused Women's Centre. So that being said, it's because I have a deep appreciation for your work that I wanted to start with you on this. One thing that I know Locke has done a lot on, which I was hoping to see addressed in Bill C-16, is human trafficking. And we know this has a direct connection to intimate partner violence in some cases. And we also know that London, St. Thomas, that whole 401 corridor has really become a terrible hotspot for these sorts of crimes. Could you speak to what you think the law could do that would better address that concern?
Sure. Thank you so much, MP Lawton, for your question. So you're absolutely right. London and area have been recognized as a hub for sex trafficking because of our proximity to the 401 corridor. And so I think it's really important to look at it as a full picture. We need to focus on prevention and education. We need, as young as elementary school, educators need to know what to recognize when it comes to human trafficking and what to do about it and how to respond. As well, we need organizations like ours that can support women and girls that have been subjected to trafficking, and not in a way that's going to be an overnight fix. We know, based on the work that we do, that it takes quite a while for a woman to trust us, for example, to share her story of what she's been through. And so it's very, very important that we have proper resources available for women that have been subjected to trafficking as well.
When we look at intimate partner violence, there are a lot of offenses that you can see along the way that escalate over time. Bill C-16 does this. It looks at this in the context of animals. We have also seen, again, an escalation in behavior from coercive control to violence. One of the challenges we have in the system right now, as we spoke about when you testified before this committee last time, is that people who do commit in some cases, violent acts against intimate partners are not staying behind bars. And we've seen in London the tragic consequences of this with Brianna Broadfoot. We also see in this that there has been an attempt to restore mandatory minimums with some guardrails. But do you believe that mandatory minimum sentences can actually save lives and can protect women, and that those are an important part of sentencing?
Thank you for the question. I think my answer is going to be similar to the last answer, even though it's a completely different topic. I think that all of the systems need to work together, right? So we need to look at what the minimum penalties would be and how they would apply. When you're looking at high risk repeat offenders, that's going to look a lot different than something that's considered maybe less of a serious charge, right? But I'm going to go back to the prevention and education piece as well. We need to look at alternative, methods to justice as well. We often hear women share to us, or women will share with us that they, want to choose what their journey to justice looks like. And so it's very important to have multiple different avenues for justice. But with regards to mandatory minimums, again, I'm going to circle back to what I said at the beginning. It's really important to look at what crime is being committed, because it's not, one size fits all.
A point you raised when you testified previously that I think is relevant to C-16 is that decisions around sentencing, and in that context bail, are actually life or death decisions for some women. So I think there is an urgency here that we get this right as much as possible. What do you think we could do beyond what's in the bill already? What's missing from this, understanding that we are tasked with looking specifically at federal legislation and can't necessarily in this bill solve all of the interconnected system challenges you've raised?
Yeah, thank you so much for the question. So I think it's important to look at what can be done, and I know this is federal, and for example, police have a really big job to do when they're responding to these calls, to these crimes, right? And so I think it's important that we look at that in a way of, I want to say, police operations. And now I know that that's not a federal issue, but we need to look at proper training, proper education, and the way that the systems, including policing, are implementing these offenses. You brought up Brianna Broadfoot, for example, but between the years of 2023 and 2024, there were 4 femicides in London alone. Those 4 women lost their lives because of their intimate partners. And so we need to look at what's going on in these situations and how we can do better as a community together, not, in isolation. And so I think, what you said is absolutely true. We need to be looking at, those high risk repeat offenders and what we're doing and why they are being released, especially when, and I, had mentioned in that appearance before you around the issues of strangulation, for example, right? And we need to take all of that seriously, and that's going to come down to training and education across the entire justice system.
Thank you.
Great. Thank you, Mr. Lawton. Ms. Dillon, over to you for 6 minutes.
Thank you to all of our witnesses for being here today. I'll start with Ms. Saint-Germain. Bill C-16 addresses gaps by criminalizing the invitation for a child to expose themselves for a sexual purpose, and by creating a new offense for recruiting youth into crime. In your view, how important is it to close these kinds of gaps to better reflect the realities of how predators are operating today? Thank you.
Thank you for the question. The invitation to expose it and modifying that particular offense is definitely necessary to close the gap. A lot of offending when it comes to that particular offense is occurring online, where that is the invitation that is happening by the offender in terms of what they are asking the child to do. So that is a very important provision to be adding to the code. The other one that you mentioned in terms of the recruitment of a child, that one is another important one. I did not mention that in my opening remarks, primarily for the interest of time. One thing that may bear looking more closely at is whether or not the offense itself needs to have the limitation that the person be in a position of trust or authority. There is a lot of case law that has developed in the meaning of that term. And although I know there is a provision in the bill that is clarifying that if the person is over 18, that puts them in a position of trust or authority, that doesn't quite accord with how the case law has developed. So there might need to be some tweaking on that. But fundamentally, the recruitment of a child to commit a criminal offense is real. It happens. And so it is important to have that reflected in our offenses.
And could you please speak to the engagement that your organization has had with the government in developing these measures, and whether you feel that the bill reflects the expertise and recommendations of organizations such as yours will work to protect these children?
Right. Our organization is constantly sort of reviewing case law and picking up on various gaps, and we put together sort of documents to assist in terms of ideas that may be helpful in terms of criminal code reform. So some of the provisions that ended up in this bill are the product of previous sort of advocacy by our organization. The 161 changes that I mentioned in my opening remarks are an example of that. So we believe that criminal law reform is an ongoing process. This bill does a lot to close a lot of the gaps that we see. We certainly have some other ideas that we would like to put on the table, but we understand the bill the way that it is, and we are very, very pleased with a lot of the provisions as they pertain to children.
Thank you. My next question will be for Ms. Sabo. The bill would expand mandatory reporting obligations to include all online platforms, extend data preservation to 12 months, and improve transparency. From your experience, are these tools essential for law enforcement to effectively stop offenders?
They are without a doubt vital. I think right now when these offenses occur, a lot of it is a child at home alone, and parents feel like they don't know what to do, and they don't even know where to begin. And so if the reporting, if the data is saved and it gives more power to law enforcement to give them the time needed to approach it, because they need to keep in mind, and I think it needs to be remembered that trauma-informed care is vital when it comes to handling especially minors and even their parents. There are many layers of trauma to these types of offenses. And so in preserving the data and giving the law enforcement time to review the case, that can add to providing the trauma-informed care that I think is absolutely vital when it comes to working with children as victims.
And you've spoken at length about the rise of online exploitation, including the non-consensual distribution of intimate images. Bill C-16 would also create a specific offense for threatening to distribute child sexual abuse material. Would you agree that explicitly criminalizing sextortion in this way is the necessary and overdue step that was needed?
I agree. It's very overdue. In the last just over 10 years, this offense has increased almost 350% in Canada, which that is an atrocity and something that we are very far behind on. And so in particular, we've heard from our communities, parents, guardians, teachers, educators, and our supporters, again, that they don't know how to deal with this. And so we've developed resources purely funded by our donors to deal with this and to educate the public about it. So without a doubt, we are behind in this, and I welcome this being part of our legislation.
Okay, thank you so much.
Thank you, Ms. Dillon. Mr. Fortin, over to you for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Thank you to our witnesses for being here with us today. I will be asking questions in French. You have access, as the Chair was saying earlier, to have interpretation on Zoom and tell me if there's a problem. But my first question is from Ms. Dunn. You talked about the importance of education, of training police officers and lawyers, etc. What kind of training would that be? I'd like to hear your opinion. So what training could be given upstream to men, women, and children in today's society?
Double hearing Mr. Fortin, so I can't hear the questions. Thanks.
Merci, Monsieur le Président.
Thank you, Chair. So the question for Ms. Dunn is, when it comes to education, of course, police officers and lawyers, there's a time period of 2 years before the provisions go into effect in order to give people the chance to obtain training. But I'd like to hear what you would have to say about the kind of education that could be given in schools and elsewhere for women, children, and men. How can we help them upstream to prevent coercive control behaviors and violent control, if it's possible, and tell us if it's possible and what kind of training?
Thank you so much for your question. So mandatory ongoing and accountable training on very specifically on coercive control, trauma and violence-informed practice, systemic bias for police, crown attorneys, and judges. And it can't be optional. It has to be mandatory, and it has to include accountability measures to ensure that it's actually being applied in practice. And so that's, at a high level for police, crown attorneys, and judges. But as young as elementary school, as simple as healthy relationships, that can be taught very easily and put into the curriculum. And again, I know that this is federal and that would be provincial. And then I'm going to give you an exact example of something that we do here from the London Abused Women's Centre. It's a program called Coaching Boys into Men. And so this is a program where our staff go out and train coaches for high school teams on how to have healthy relationships and how to be good men. And it's as simple as that. And it can start very young.
Est-ce que vous avez l'impression que ce type de programme...
Do you feel that this kind of program works or not? And if it doesn't work well, how we could improve them? Because the increase of violent crimes and coercive control and intimate partner abuse, the number of those offenses is increasing, not going down. I may be wrong, but I get the feeling that we're not doing enough to have a upstream prevention. Yes, there are amendments to the criminal code. We can have more severe sentencing. But as a society, is there anything that we can do to prevent people from developing those kinds of behaviors?
Thank you so much for your question. I think that you're absolutely right. So prevention really and truly means identifying and responding to risk before violence escalates. So for example, I had mentioned off the top when I was speaking about our high-risk action table for femicide prevention, where you're bringing multiple systems together to share information and intervene early before something happens. It also means investing in areas like housing and income and services that allow women to leave, safely, education, school boards, all of that. I want to suggest that I don't think that prevention and education is funded properly, and so that's one of the issues. I mean, our organization here, we do have provincial core funding for our core services, but for example, anything else that we want to do, for example, as it would relate to prevention and education, we have to apply for money to be able to do that, and so it's really important it's funded.
Merci, Madame Dunn. Je m'excuse.
Thank you, Ms. Dunn. I'm sorry, I don't want to be impolite, but I don't have a lot of time. I would like to ask a question to Ms. Saint-Germain. You talked about the issue of recruiting children to commit offenses. Bill C-16 proposes an approach, and a number of us have different ideas on that. But how do you see the issue? So if there is an adult who approaches a child to commit a crime, I think that it is even more severe than committing the crime itself, in my view. So I think that the person who does that should have should do twice the time than they would have to do if they did the crime themselves. So how do you see this issue when children are recruited to commit offenses? What would you propose?
Well, I mean, it's definitely a serious issue, and sort of the length of the sentence is something to talk about. When it comes to sentencing, as we know, it's very individualized, and the way the judges approach these things are using a lot of different sentencing principles, et cetera. So I'm not sure if having it in the code that it's double the sentence, if that would actually have the desired effect, because I think it would end up getting cut down in some way. More importantly, I think, is recognizing the seriousness of this type of activity by having an actual criminal offense that speaks to it. We definitely will see things like this happening in the context of, say, human trafficking or exploitation through prostitution offenses. So these are all very important things to tackle. And to the previous question that you asked, one thing that I would add to what was said would be the exposure to pornography that we have in our society to young people. That may be something that we want to tackle.
Thank you,
Merci.
Mr. Fortin.
Fini?
Thank you. I'm done.
Earlier too, so.
Oh, Madame Zabo, rapidement.
So, yes, Ms. Zabo, quickly, you talked about a lack of data, a lack of information. What are those missing data, and what can be done to obtain them?
Thank you for your question. We find when we are developing resources, specifically, we're missing Canadian data. There are a lot of studies we can get out of different states, which we think perhaps have somewhat of a reflection here in Canada. But specifically, we're looking at trends and gaps in prevention. As you heard from my colleagues here, prevention is key. And so we would be able to identify the gaps if we had data on trends and prosecution outcomes specifically.
Thank you,
Merci.
Mr. Tablet. Thank you, Mr. Fortin. All right, Mr. Gill, over to you for 5 minutes.
And thanks to all witnesses. My question to Ms. Dunn, in your opening statement, you talked about the femicide provision in this bill. I'm going to ask a few questions about this subject. So is making intimate partner violence a first-degree murder charge enough, in your opinion?
Thank you so much for the question. I think it's a good step. I definitely do not think it's enough.
Okay. And as you said, this is a good first step. What are the next steps which need to be taken, in your opinion?
Thank you so much for the question. I feel like I'm going to end up repeating myself a little bit, but I think it's really important to have a sustained investment in prevention to address the root cause of male violence against women and the systemic barriers that women face. You know, without that, there's actually going to be nothing will happen. Women will continue to lose their lives.
I'm asking about the next step because this Liberal government brings or introduces the bills and take first step, and they always take first step. And they, however, did not address the root cause and do not take any further steps needed to improve the legislations and provide support to the victims. What is your answer to that?
Thank you. I think it's important that we look at this in multiple different directions. So the legislation is one piece, but we also have to look at proper funding for organizations like ours. I mean, not all women are going to choose to or want to report to police. They are not going to want to go through the criminal justice system for whatever their journey to justice looks like, they're going to want to, come to an organization like ours. And so it's really important that organizations like ours are properly funded. And then I'm going to go back to prevention and education as well. Prevention and education must be funded by all levels of government so that generations can continue to learn about what is wrong and what is right. And that's the only way that we're going to be able to make proper change.
Okay, so you talk about the training and programs that needed. Do you know the government is taking these critical next steps?
Thank you. Just to clarify, are you asking if I know if the government is taking those steps?
The steps that you have suggested that need to be taken in terms of programs or funding you were talking about?
Yeah, I think, from time to time, I think I had referenced before, so I can speak about our organization specifically. So we receive core funding from the provincial government, but we also receive time-limited grants and funding from the federal government as well for these exact type of initiatives. And so I do think there have been opportunities for this, but it needs to be more. We need to have more access to core funding so we don't have to, use our resources, for example, to apply for funding and then turn around and report on the funding. So we need longer opportunities for funding.
Okay, so how will victims be affected without these programs or training, in your opinion?
Thank you for the question. I think it's important to look at, again, and I'm sorry that I repeat myself about this, but it's not one size fits all, right? Like women need to be in the driver's seat when they are wanting to heal or, get through what they've been subjected to, if it's intimate partner violence, or like we're talking about coercive control. And I think it's really important that there are options for women when they have been subjected to violence. And so I had touched a little bit on something that we're doing here in London, and it's a high-risk action table for femicide prevention, where organizations across sectors come together and really work in a collaborative way to identify and intervene. And I think, it takes everybody coming together, and we can't be siloed when we're doing this work.
You also told this committee in October that when a violent offender is released, survivors are often forced to relocate, leave work, or lose their jobs or live in hiding. These are not just disruptions, they are losses. They are losses of safety, identity, and stability. For the sake of the victims, should violent and repeat offenders serve stronger and longer sentences?
Very short answer, please.
Absolutely. A violent and repeat offender needs to be held accountable for what they've done. 100%.
Bill, Mr. Housefather.
Thank you, Mr. Chair. Ms. Szabo, Ms. St. Germain, Ms. Dunn, thank you very much for being here with us today. Ms. Dunn, I'll give you a break since you just answered all these other questions. I wanted to get to the issue of images, intimate images, that is a subject covered in the bill. It's also covered as part of deepfakes. One of the things I think that you raised in your opening statement, Ms. St. Germain, is the issue, you talked about it with respect to bestiality, the issue of criminalizing the distribution but not criminalizing the creation of the materials. I think this is also true with respect to deep fakes. Can you, and if anybody wants to elaborate as well, could you talk to what your organization believes we should do with respect to adding to that section to include the creation of material and why?
Right. Well, when it comes to the intimate images, I can hear an echo, so when it comes to intimate images, the creation is what sort of starts the cycle of victimization for the victim. What we are seeing is a tsunami of instances and examples where these types of images are being created, primarily of women and girls. So this is a very gendered issue. And so while we are happy to see the distribution of deepfakes being added into the intimate image offense, as well as the addition of the threats portion of that offense, we do believe very strongly that the creation of these images also needs to be tackled. And it may be that there has to be some additional studies and some additional sort of information to have it be constitutionally compliant, but I believe that it's possible, and I believe that the safety of women and girls in this country demands it.
Sorry, can I just ask you an additional, sorry, because I only have 5 minutes.
Sure. Yeah.
When it comes, because we have only until next week to come up with amendments to the bill, so I really wanted to delve into this. In terms of the creation, when it comes to deepfakes, which is not actually an image of the person, could you talk about what harm could be created in your view with respect to a deepfake that is never shared?
So even if it's never shared, it can be used by the person to enhance cognitive distortions of that person about the person who is depicted, as well as if you've got images of a lot of different women, for example, that can help to make you feel like women are sort of available for you in whatever sort of context you might be able to dream up. So I think there's a harm to women generally and to girls generally in terms of the existence of these images, even when they are held for private use.
And when it comes to, for example, an intimate image, an actual intimate image that was taken consensually at that point. So when it comes to an actual intimate image, provided it was done consensually and it was somebody who was an adult, presumably that could not be criminalized. It would become criminal in the event that actions were taken with that intimate image. But you think with respect to the deep fake, that would be different, and just the creation of the deep fake itself should be covered. I think I understand. And the
Yes.
same would be true with the bestiality image, as I understand that.
That's correct. So with the bestiality, the issue there is a little bit different in terms of, I wasn't talking about the deep fake, but just about the sort of possession and having the bestiality depictions be covered in the same way that child sexual abuse material for all of the same reasons.
And then I wanted to go to Ms. Dabo because she raised a different part of the intimate image issue, which is that most of the victims, besides the criminalization issue, the criminalization is one part of this, but there has to be other things because you need to get this thing off the internet in order to deal with the primary thing that the victim is concerned about at that moment in time, which is the continued the harm that is being done by it being on the internet. So, Ms. Dabo, could you sort of talk about how you see that parallel track with what we should be imposing on the platforms with respect to takedown?
Absolutely. There has to be a mandatory time frame for takedown, no exceptions. When you think of the ongoing trauma that this could inflict on Canadians, especially young Canadians who are underage. We tell our children the internet is forever. And so when these large tech companies have they don't have any reason to kind of act on these things in any sort of timely fashion. But we know it's possible. We definitely know that we may have to hit them where it hurts. It may have to be a financial
Thank you.
penalties.
I'm going to have to stop you there. Yeah. We're running tight on time, that's all. Mr. Fortin for 2.5 minutes.
Madame...
Ms. Dunn, I'm coming back to you with regard to the issue of training. Do you know whether there, in any of the Canadian provinces, there are programs that address the issue of intimate partner violence, either in schools or with adults? And if so, which programs should we be focusing on as good examples, or what problems are there with regard to funding, etc.?
Thank you for the question. I think there are many organizations like ours that have multiple, there are many types of programs and initiatives out there that provide training and education to all different types of sectors. I think, what I could do, if you would like, MP, is I'm more than happy to send a list of programs and education measures to the clerk of the committee for you to go through if you'd like.
S'il vous plaît, Madame.
Yes, please. That would be much appreciated. It's a great idea. Ms. Szabo, same question. To your knowledge, are there any provinces that are doing a better job than others when it comes to educating children or couples?
We are a national organization, so I can only speak to the fact that we have heard from all over Canada that education is necessary. But again, it goes back to funding. Again, as my colleagues have said, we need continued funding so that we can approach this holistically. Parents are only one line of defense, educators, people who naturally intersect with children on a day-to-day basis. So it really does go back to sustained funding, whether it's provincially or federally.
Merci, Madame Szabo. Madame,
Thank you, Ms. Szabo. I have about 30 seconds left. Ms. Saint-Germain, I'd ask the same question. To your knowledge, are there some provinces that are doing a better job than others with regard to educating children and adults when it comes to intimate partner violence? Thank you.
Right. Well, our organization has educational programs that are delivered in schools across the country in both official languages. So what we see is almost 100% coverage in the province of Manitoba right now in terms of the programs that we have, which are sort of year over year, starting from elementary school right up until high school, focusing on respectful relationships, focusing on privacy issues, etc. It's called Kids in the Know.
Thank you very much.
merci.
Ms. Cronus, to you for 5 minutes.
Really struck by your comment in your opening remarks about how disheartening it is to see the Supreme Court of Canada strike down offenses related to the sexual exploitation of children like they did in Senneville based on reasonable hypotheticals. And while C-16 doesn't prohibit the courts from using hypotheticals in their reasoning, Section 63, the so-called safety valve, does make exceptions in some cases to sort of preserve and signal the importance of mandatory minimums for things like murder and treason. And so what I was wondering is whether or not including offenses related to sexual exploitation of children into Section 63, the safety valve, whether or not that might address your concerns.
We actually feel that the provision that's been added into C-16 is a reasoned response to the jurisprudence that exists. The reality is that that we have the case law that we have on mandatory minimums. And from our perspective, since the Friesen decision was issued in 2020, sentencing when it involves offenses against children have improved considerably. And when we talk about edge cases, which is what the hypotheticals were really focused on, that's where you start to lose sight of what the harm actually is in the vast majority of the cases. And from our perspective, this safety valve should help to preserve the mandatory minimums for the vast majority of cases that actually do reach the courts in this country.
To dig into that a little bit, because I'm wondering how it does that, because it doesn't, if the reasonable, what I worry about is that the cases that would cause the safety valve to be used become the very hypotheticals that then allow the whole offense to be struck down. And so if you're getting out of edge cases, like if there's a case that's in front of the courts, then it's not an edge case. And how do you, I worry that they will also decide that there are edge cases as well, and that it might actually increase the probability that the law gets struck down. Do you see where I'm getting at?
Yes, but the safety valve is about sentencing. It's not about the offense itself. So that would be a different issue, challenging the offense and the constitutionality of the offense and what it covers. Whereas the sentencing part is about what the sentence actually is going to be and whether or not a mandatory minimum is justifiable in the case of the specific offender that's before the courts and the specific offense that offender committed.
I don't think that you don't think that defense counsel will then use that to argue that the offense itself, because of the way that it was structured, you're not concerned that there's going to be additional litigation as a result of this?
I didn't say that. What I was talking about was the difference between sentencing and the offense itself. There's always going to be constitutional challenges to offenses, and we expect that will continue. But the safety valve provision is about preserving the mandatory sentences to the greatest extent possible in light of the jurisprudence we actually have.
Right, but it is the sentence, it is the mandatory minimum, it's the sentence that actually gets struck down in these circumstances. And we get into a bit of a circular loop, as you can see from the question itself. Are there amendments that you think would help under these circumstances? Like, are there amendments that would solve the circumstances that are causing the disheartenment?
So the safety valve will help in terms of reducing the amount of litigation that is then focused on hypothetical scenarios, because the safety valve itself is saying that when you're imposing something less than the mandatory minimum sentences, it's when that mandatory minimum sentence would be cruel or unusual as applied to that offender. Whereas the way that things were working prior to the safety valve is that the courts could come up with a hypothetical and then use that hypothetical offender that wasn't before the court and that offense being committed in that way that also wasn't before the court to say, well, in that circumstance, this offense would be, or this sentence, would be excessive. So what we do see is that the cases where the mandatory minimum sentence or where a court is imposing less than a mandatory minimum sentences are not it's not that often. And when it does happen, there are sort of some extenuating and exceptional circumstances that do exist.
Do you think that a 1-year mandatory minimum for child pornography is reasonable?
Very short answer.
Absolutely. We've always been supportive of the mandatory minimum sentences for child sexual abuse and exploitation material.
Thank you, Ms. Cornish. Okay, last to you, Ms. Latanzio, for 5 minutes.
Thank you, Mr. Chair, and I want to thank Ms. Dunn, Ms. Saint-Germain, and Ms. Scavo for being here today and helping us do our work with Bill C-16. So my first question will be addressed to Madame Saint-Germain. The bill would significantly enhance the Mandatory Reporting Act by extending data preservation timelines, broadening its application to all online platforms, and increasing transparency. How, in your opinion, do you believe that these changes will improve the law enforcement's ability to detect, investigate, and prevent child sexual exploitation online?
Right. So the mandatory reporting by providers is a very significant contributor to identifying cases that do need to be investigated for law enforcement. So the Mandatory Reporting Act has always been an important act. There's mandatory reporting that happens in the U.S. that also triggers a lot of Canadian investigations. So the amendments that are being made in the mandatory reporting legislation are really important because they are clarifying the scope and extent of these obligations for Canadian companies and making it clear that it's covering companies that provide internet content hosting, as well as those who are incorporated in Canada, have their head office in Canada, et cetera. So those are all very helpful amendments.
Questions are going to be to Ms. Scavo. Your organization and you yourself in your opening remarks, you highlighted that online child sexual exploitation has increased in the last years, reaching record levels. In light of the alarming trend, Bill C-16 would restore mandatory minimum penalties for offenses such as making, distributing, possessing, and accessing child sexual abuse material, offenses that the courts have previously struck down in both Senneville and Pike. From your perspective, working with survivors, how important is it that the law clearly reflects the gravity and the lasting harm of these crimes through meaningful sentencing?
I think meaningful sentencing is one component of the entire approach when it comes to supporting survivors and victims. I think it's vital that the seriousness of the offense is reflected in the sentence. However, I would also argue that the seriousness of the offense can be reflected in funding and supports that are given to survivors and victims of the crime, whether that's after it's occurred or through prevention upstream of judicial system and education. But I think that is one component.
And based on your frontline experience preventing child exploitation, sexual exploitation, and supporting victims, do you believe that the proposed sentencing reforms in Bill C-16, including the restoration of mandatory minimum penalties, are aligned with what is needed on the ground to better protect children in Canada?
Again, it is part of what's needed to protect children in Canada, but I cannot stress enough how important prevention upstream of these systems is.
Bill C-16 also updates the child luring offense, as both my colleagues have pointed out this afternoon, to capture extortion-related conduct. Given how predators now operate online, how often manipulating and coercing youth occurs, would you agree that this change better reflects the reality of your organization is seeing on the ground?
Yes, definitely, and it's something that's happening every day, as our friends at the Canadian Centre for Child Protection have echoed. So yes, we do support that.
Do you have data that you can share with us in terms of how much of it is happening? Because you said that we're reaching record levels. Do you have any data that you can provide the committee with?
The initial statistic I provided was that since 2014, online sex torsion cases have increased by 347%, but I would let you know that a lot of that occurred, there was a massive uptick during COVID when everyone was inside and the screen time for children increased.
Okay. How much more time, Mr. Chair? 30 seconds. I have no more questions.
Okay. Thank you. All right, thank you to all of our witnesses. We appreciate your time, making the time to be here today, and for your valuable contribution to this discussion about Bill C-16. I will let you go. We'll suspend for very briefly. Please, people, don't run away, because we can jump right into the next panel. Call the meeting back to order. Before I get to the second set of witnesses, I want to just read something. Before we begin, I would like to say a few words on parliamentary privilege in the context of our study of Bill C-16, the Protecting Victims Act, which, as you know, could raise sensitive issues, personal matters, or even legal matters involving the witnesses appearing before us. It is well established in Canadian law that parliamentary proceedings, which includes the deliberations of this committee, are covered by the parliamentary privilege of freedom of speech. The most fundamental and ancient right protects parliamentarians and witnesses appearing before committees for anything said in the course of parliamentary proceedings, any comments made during today's meetings cannot be used in a legal action against the person who made them or to attack that person's credibility in a court of law. That said, parliamentary privilege does not apply if the comments are repeated or reproduced outside of this committee's proceedings. Anyone wishing to consult today's proceedings should be directed to the committee's official website. Okay, on that note, we are pleased to be joined by, as an individual, Kendra Cook. Thank you for joining us. From the Ontario Child Sexual Exploitation Investigators Association, we have Andrew Ulach, the board chair, and Lisa Henderson, a member. And from the Raoul Wallenberg Center for Human Rights, we have Angela Marinos, Chief General Counsel. Thank you to all of our witnesses for joining us. The process is each individual or group will be given up to 5 minutes to make opening remarks, and then we'll open the floor to questions. Ms. Cook, just since you're to my left, I'll start with you.
Certainly. Good evening, and thank you, Mr. Chair. I'm grateful for the invitation to speak today regarding your study of Bill C-16. My name is Kendra Cook, and I am here to reflect my experiences of intimate partner violence and coercive control. I experienced coercive control throughout my marriage and continue to be subjected to these abuses more than 3 years post-separation. Here is a list of just some of the ways I have experienced and continue to experience coercive control. Dozens of false reports made against me to police, Children's Aid, healthcare providers, and the children's school, repeatedly urging me to kill myself and offering to give me one of his firearms to do so. Isolation from family and friends, limiting my ability to work, stalking and surveillance by my ex and a work colleague of his, abhorrent and harassing communications in person and through phone, social media, and a court-ordered parenting app, disregarding numerous court orders dictating the content and tone of our communications and contact, employing the legal system to perpetuate harms, financial abuses, intimidation through the purchase and display of firearms, psychological and emotional abuse of our children during his parenting time, withholding child support and employee health benefits for the children, warning me that he has befriended a judge who would be presiding over our family court case, threatening that he would gain full custody of our children, weaponizing the justice system against me, involving our children in parental conflict, eroding their sense of safety and well-being, having me criminally charged without providing evidence to police or Crown Attorney, threatening to kill me, my parents, my current partner, and her children. For years, I have sought support to safeguard my family from these abuses and their far-reaching consequences. Unfortunately, all of the child welfare and justice systems I have encountered are woefully ill-equipped to respond to the abuse we are experiencing. I have routinely been told that because there has been no physical violence in the home, there was nothing anyone could do to help me, and that self-help would negatively impact my efforts to secure divorce and custody agreement in family court. I met the criteria to live in a second-stage residence for women who have experienced violence, qualified for supports through victim services, and consistently scored as high risk for spousal assault through Be Safer, a tool developed by Canada's Department of Justice. Even a court-ordered investigation by the Office of the Children's Lawyer and subsequent report detailing serious concerns regarding my ex's abusive behaviors has not been enough to end the abuse. My experience makes it gravely apparent that the professional expertise of social workers and counselors is not acknowledged within the systems that could actually intervene to create safety and to hold perpetrators to account, and that those systems do not operate in a legislative framework that supports victims. A move to criminalize coercive control must include efforts to educate actors throughout the justice system and across jurisdictions. As stated in the bill, coercive control can only be defined through a pattern of coercive and controlling behaviors experienced over time. Demonstrating these patterns becomes nearly impossible for victims because every part of the justice system is designed to operate in a silo, systematically disregarding evidence and experience that occurs outside of it, not to mention the unreasonable burden of proving an intent to harm in the current writing of this bill. We must recognize the authority of professionals working to support victims to affirm experiences of coercive control when police and courts are investigating such crimes. It may also be imperative to adjust other laws and interventions to align with the language in Bill C-16, particularly that a person's safety includes their psychological safety. For example, in order to be granted a peace bond, the applicant must have prior physical assault. I learned this the hard way when I applied for a peace bond, being advised by the Crown Attorney that current legislation does not support issuance of such, given the lack of physical harm I had experienced. Unsurprisingly, angered by my efforts to seek a peace bond, my ex retaliated by having me arrested and charged for a crime I did not commit without providing any evidence. This experience was traumatic and violating and continues to limit my ability to contribute to my community and provide for my family. In closing, a collaborative approach across systems, along with public education, will be necessary to achieve any positive outcome from the criminalization of coercive control. I urge this committee to carefully consider the work of the Standing Committee on the Status of Women and their report on coercive control in Canada, in addition to the witness testimony you hear, as you continue the crucial work of studying Bill C-16 and its potential implications in the lives of victims. Thank you.
Thank you, Ms. Cook. Ms. Marinos?
Bonjour, mesdames et messieurs du comité. Merci de m'avoir invité.
Hello, members of the committee. Thank you for inviting me to contribute to the important work you are doing on Bill 16 on victim protection. My name is Angela Marinos. I am the head general counsel for the Raoul Wallenberg Center, founded by the Honorable Irwin Cotler.
Center a couple of years ago, after almost 23 years of litigating at the Department of Justice, where I represented the Attorney General of Canada and various federal ministers across a number of governments, across party lines, and across all levels of court. As such, I'm well familiar with defending federal decisions and policies and the law as it is. But today, I'm here to advocate for the law as it should be. Je pense aussi et j'espère que mon expérience devant la Cour.
I also believe and hope that my experience at the Supreme Court on behalf of the Raoul Wallenberg Center will be able to inform your study.
5 main proposals, but in the time I have, I want to focus on 3. Independent legal representation, providing a holistic trauma-informed approach to our understanding of exploitation in the trafficking context, and adding human trafficking and sexual services offenses to the protective screening mechanism at Section 276 of the Criminal Code. Before I elaborate on these issues, I want to commend the broad reform that's been proposed with Bill C-16, and at the same time, we believe this bill can be strengthened in a handful of areas. The biggest transformational change to this bill would be providing independent legal representation for victims and survivors of sexual violence and sex trafficking from the moment they engage with the legal system, when they go give their statement to the police, to appearing in court. Why are we asking for this? Because we've seen victims torn apart by the legal system time and again, because they don't trust the system as it is, as demonstrated by the fact that 94% of these crimes are not reported to the police, and because victims and survivors do not have a meaningful voice in the judicial system. The Crown is not their voice and cannot be their voice, and currently there are, as you know, very limited circumstances where complainants have independent legal standing. This is not enough. We can and must do better. We've done it before, and we can do it again. Given the time, I'm not going to touch on our other proposal, where we seek an independent right to counsel, where the Crown seeks to admit evidence of prior sexual activity, or where there is a joint application, but those submissions are detailed in our brief. I want to move very briefly to our second proposal with respect to exploitation, and then touch on Section 276. We are urging a holistic trauma-informed lens to be applied to the definition of exploitation and to make trauma and PTSD an integral part of the definition. We're also asking that the definition of exploitation include the belief that the safety of their residents or pet is threatened if they fail to provide the labor or service. And we are asking that the term manipulation be added to the factors that should be considered. Turning to Section 276, we submit it's important to specifically enumerate human trafficking, sexual services offenses, and other sexual offenses. Why? Because otherwise, defense counsel will argue and the courts will find, as they did at the Court of Appeal in R versus AM, that it was Parliament's intention to exclude them. Does Parliament really intend to exclude the benefit of Section 276 from these groups? I find that hard to reconcile with Parliament's stated intention to protect the dignity, privacy, and equality interests of these vulnerable groups. Now, I appreciate that the proposed amendment seeks to add the phrase, or any other offense under this act that is of a sexual nature or that is committed for a sexual purpose. However, as we submitted in the brief, and as one of the Supreme Court judges put it in the R versus AM appeal, that will be rife with litigation. That phrase will only bog us down in arguments that the offense was not committed for a sexual purpose. The solution then is to list the offenses. In closing, we know this government and this committee want to be transformative and are committed to providing those subjected to sexual violence and sex trafficking with better, stronger protections. We can do this, and I urge you to accept the changes. Thank you for your time and consideration.
Thank you very much, Ms. Marinos. Over to you, Mr. Ulak or Ms. Henderson, or both, if you're going to share the time.
Good afternoon, members of the committee, and thank you for giving us the time to share with you the perspective of the Ontario Child Sexual Exploitation Investigators Association, or OXIA, on Bill C-16. Our organization includes law enforcement, members of the private sector, and retired Crown attorneys, and we bring with us a considerable depth of knowledge and expertise that we feel can assist the committee as it deliberates C-16. There are several sections in C-16 that, if passed, will have a significant impact on the investigation and prosecution of offenders who use the internet to harm children. It is these sections that we wish to focus on. First, we would like to emphasize the importance of restoring mandatory minimum sentences for offenses in the criminal code, particularly child exploitation offenses. Because the Supreme Court has struck down mandatory minimum sentences for most online exploitation offenses, conditional sentences are available for offenders who seek to prey on children in a sexual manner. It is the position of OXIA that nothing could be more unreasonable than allowing offenders who do so much harm to the community to serve their sentences in the community. We would confidently argue that there is no realistic scenario where an individual would be convicted for an online exploitation offense and not merit a custodial sentence. The proposed revisions in Section 63 of C-16 that reestablish mandatory minimums in the criminal code with a safety valve built into it is an important step for Parliament to take to send a message that society will not tolerate the online exploitation of children. Second, we would like to speak to the importance of the proposals in Part 15.1 of C-16, which deals with the way courts address unreasonable delay in trials. OXIA respects the importance of protecting the rights of citizens guaranteed by Section 11B of the Charter. However, under the current state of law, the courts have only a single all-or-nothing remedy that results in an entire case being thrown out when, for any number of reasons, the Crown is not able to complete the trial of the accused in what can only be described as an arbitrary time limit. The proposals being put forward in Part 15.1 will allow for a more reasonable and just assessment of whether or not the accused was tried within a reasonable time, and allow for a range of remedies that can be applied that is proportional to the degree in which 11B has been infringed upon in a given case. This is important to members of OXIA since most of our cases are highly complex and require the analysis of huge volumes of data. This data analysis usually occurs after the arrest while the Jordan clock is ticking. OXIA believes there is a high societal interest in seeing online child sex offenders held to account, which means the Jordan timeline assessment must be a realistic one that takes into consideration the complex and unalterable nature of these kinds of investigations. Lastly, We would like to provide the committee with a sense of how urgent it is to update and reform our laws to deal with the very large and persistent threat that endangers all children in Canada, regardless of their social status, background, language spoken, or geographic location. In the last decade, the exploitation of children has increased at an exponential rate, and our laws in their current state are simply not sufficient to keep up with this problem. And you don't need to take our word for it. We would like to share with you the perspective of a sextortion expert that we obtained from his user manual that he recently published for free over the internet. And we would like to be clear, when we use the term sextortion expert, we are not referring to an internet safety expert who lectures to parents and kids about how to stay safe online. What we mean by that term is a person who is an expert in committing sextortion offenses against, according to him, over 5,000 child victims over 7 years. This offender published an over 100-page how-to manual to teach others how to be successful in victimizing children over the internet in the most heinous of ways. Having read the manual, I can tell you he knows what he's talking about. In the intro to his manual, this offender answers a question that some of you might be asking. He states, "But why is sextortion the fastest growing crime in the modern era?" The reason for this is simple: power. Sextortion is an escape from the daily lives of perpetrators who seek to exert control and dominance, and they cannot do that in any other way. By exploiting their intimate photos or videos, they manipulate and blackmail victims into submission, gaining a sense of power and gratification. Additionally, the anonymity provided by the internet makes it easier for the perpetrators to carry out these acts without fear of being caught, further fueling the growth of sextortion as a crime. Sextortion is much more than the basics. Once you successfully acquire an obedient victim who has everything to lose, their fear of being exposed is just the beginning. They become a cyber slave, willing to do anything for you, no matter how difficult and painful the task may be. This brutally honest confession from a skilled online offender demonstrates the scale and importance of the task we'll face. Canada must do more to catch and deter these offenders and protect our children. If this is not a top priority for us, what does it say about us as a country? Thank you, and we are happy to take your questions.
Thank you, sir. Okay, we'll start with Ms. Kronos, I believe, for 6 minutes.
Thank you very much, Mr. Chair. Ms. Marinos, I'm actually hoping to take advantage of your keen legal mind today. I'm wondering if I could ask you a few questions about the safety valve provisions. And specifically, do you agree that Parliament enacts mandatory minimum penalties to set a clear floor for sentencing? Like, that's the purpose of it?
Well, I think that there are two objectives. I think that we would all agree that the mandatory minimums are there to signal Parliament's denunciation of the severity of these crimes. And I think that we all want to see those mandatory minimums pass constitutional scrutiny. So I think that Parliament has to strike the right balance.
That's a very good explanation of it. And in terms of the safety valve, that's going to allow a judge to go below the floor if in the circumstances, and it's in the circumstances, the judge decides that the minimum punishment would amount to cruel and unusual punishment for that offender. So it allows for that balance to be struck in any specific individual situation that is in front of the court. Is that correct?
Yes, I would read it that way, that the judge has the discretion with this safety valve to give us a sentence that is less than the mandatory minimum if the Section 12 Charter threshold is met.
And it's based on the circumstances of the offender.
Yes, that's my understanding.
And that's the only factor that's laid out in the section. It's the circumstances of the offender are the only criteria that are laid out. Is that correct?
Well, in the safety valve, yes, but I think that in every case the judge is taking all sentencing provisions and discretion into account.
Right, and the only circumstance where the nature of the crime comes up as a consideration is in those exceptions that are in the section, which basically amount to circumstances of murder and treason. Is that right?
Those are the circumstances, yes.
Yep, but not the impact on the victim of the crime.
Well, the impact on the victim is always considered in sentencing when the victim has an opportunity to do their victim impact statement. And of course, the judge is always balancing other considerations, mitigating factors, aggravating factors, what the crimes involve. They're always doing that balancing act.
But not through this section.
No, but there are other sections in the criminal code, obviously, that provide for that.
And there's no limit on how much lower than the mandatory minimum the judge can go, is there?
Not according to this legislation, no.
So if we have two accused that are convicted of, call it kidnapping with a firearm, which has a 5-year mandatory minimum, and equal participation in the crime, but different personal circumstances, then the judge could theoretically give one of them a 6-month sentence and the other one a 6-year sentence if the judge decided that the circumstances of one of the offenders warranted it.
Sentencing is, as you know, an individual exercise. So yes,
That's why
there's a range. There's a range, but and I'm not a criminal prosecutor. I should add that caveat. But yes, presumably there's the possibility of getting 2 different sentences.
Right, but there is the principle of parity, and so if you're looking at that kind of situation, because if let me put it to you this way, if the Supreme Court of Canada can use reasonable hypotheticals, then I've just laid out a reasonable hypothetical. You could have personal circumstances of the accused, and my question for you is, how do you think we explain that to the victim?
I think it's really hard because when you look at the jurisprudence on mandatory minimums, for the most part, the court is not striking down the mandatory minimums for the specific offender. They're striking down the legislation for the reasonable hypothetical. And, reasonable people can disagree. I was an intervener in Senville. Interveners don't have the right to take a position on the outcome. If you ask me my personal opinion, I would be siding with the dissent on that particular case. Is a reasonable hypothetical reasonable? Sometimes it is, sometimes it isn't. There's 5 people who think one hypothetical is reasonable and 4 people that don't.
But if you're looking at it from the perspective of the victim,
yes,
then where you're at in this particular scenario is that the 2 accused have participated equally. They have the impact on the victim is the same. That's right. And yet the court is going to put the interests of one of those accused ahead of the interest of the victims.
In Senville, I always took the court back to the fact that we were dealing with hundreds and hundreds of images of mostly little girls aged 3 to 10 that these 2 accused had. And explaining to those victims, and what I said to the Supreme Court of Canada was that these are not victimless crimes. We may not know who these children are. They have names, but they're unidentified. They are often unidentifiable, but it doesn't mean that they're victimless. So I completely agree that it would be very difficult to explain why this decision was, struck down. But there you have it.
Thank you.
Thank you, Ms. Kronos. Next, we have Mr. Housefather.
Thank you very much, Mr. Chair, and thank you to all the witnesses, and thank you so much, Ms. Cook, for telling your story. Is the volume okay? Yeah. Okay, sorry. Ms. Marinos, I want to start with you. In terms of you were able to bring forward 3 of the 5 main points you had in your brief. Do you want to briefly summarize the other 2 for everyone?
The other 2 have to do with, thank you for the question, Mr. Housefather. They have to do with records, and they have to do with the restorative justice. The restorative justice is just very simple in our view, that we need to ensure that complainants' voices and inputs are integrated into the restorative justice process, and that there needs to be some sort of safety valve for the situation where everyone agrees that restorative justice is a good process, but then it doesn't work. What happens then? The second one was records and therapeutic records, adding section 286.4, which we think is missing from the area of records, and also adding current and potential harm to the subject of the record or therapeutic record as a factor that can be considered. And basically ensuring that the confidentiality of the complainant's personal information is respected.
Perfect. Now, I want to get to your specific recommendation related to Section 276. I understand, which I hadn't been aware of. You're an intervener in the R versus AM. It's R versus AM, right? Yes. That case. And so basically, as I understand it, we've added in a phrase or any other offense that is of a sexual nature or is committed for a sexual purpose. Yes. But you're concerned that the general provision may not deal with some offenses that are not necessarily, the argument will be made that they're not necessarily sexual offenses. Can you explain to everyone what that means and why we should be then amending the bill?
Sure. This came up in R versus M squarely, where the defense counsel was arguing that they wanted to cross-examine the complainant, not on, the sexual services part of the offenses. That's right. But running your own business, being an independent contractor, that this was a commercial element. And when I saw that phrase, and it came up, the appeal was under publication ban, but one of the questions that came up when this phrase was mentioned was that this is rife for litigation. And do we want more litigation? We want less litigation. And I say that as a litigation lawyer.
So basically what as I understood it from your brief, you're suggesting we take the therapeutic record section of the law and add those sections to this section.
That's right. We make it consistent. There is case law that says that Section 276 and the records and therapeutic records scheme are parallel systems, with the addition of Section 286.4, which isn't included.
Okay. That makes a lot of sense, and I appreciate that because, again, this is I hadn't thought of the fact that the general would not include the specific. So thank you. I wanted to then go to your next point that you had made about exploitation, which in the current draft requires a reasonable expectation that the person's safety or that of a person known to them would be threatened. That's right. And again, at first blush, when I read that, I said, okay, well, that makes a lot of sense. This is a well-drafted provision. But what you're saying is that there's ways of threatening somebody that don't involve their physical safety. Right. Could you sort of get into that and explain to us, like I threatened to burn your house down, but you're not in it, so then I'm not threatening your safety, but I'm threatening your property, which is equally, to some extent, important because it's the whole value that you've created over your life. Could you sort of explain that for us?
That's exactly right, and it's coming directly from the R versus AM case, where the complainant had told the police, he threatened to burn my house down, he threatened to kill my cat. And so if you look at the provision as it stands, as you said, it only covers their safety or the safety of a person known to them, but it doesn't cover, I'm going to burn your house down when you're not there, I'm going to burn your parents' house down, or I'm going to kill your pet if you don't do these things. And so if we're making these changes, why not add the fuller panoply of the manipulation tactics and threats that traffickers use?
And thus introduce the word manipulation that is not currently there in the definition.
That's right.
Okay, so thank you, because we had other witnesses that came forward. Somebody, for example, said, well, it makes no sense that my dog is included, but not the dog that is owned by somebody else, because the ownership of the dog is confined to the individual concerned. So I think we do need to look at that section. Thank you. Do I have any time left, Mr. Chair?
30 seconds.
So on the question of independent legal counsel, as we know, provinces generally are responsible for that issue. We have legal aid services. Can you sort of talk about where you see the federal government perhaps cooperating with the provinces, or what? I mean, how would this bill deal with that? For example, the independent legal representation.
Right. Well, we know that the DOJ does fund ILA, independent legal advice, for various clinics across the country, although not uniformly. So there are provinces that don't get these benefits, but it's not for independent legal standing necessarily in court from the start to the finish. I know that we're running out of time, but
thank you so much.
I appreciate that.
Thanks, Mr. Hostfather. Mr. Fortin.
Merci, Monsieur le Président. Merci.
Thank you, Chair. And thank you to all the witnesses who are here with us today. This bill is significant and your thoughts are always useful. I will be asking my questions in French. And so those of you who are online, you can use the little icon at the bottom of your screen to get the interpretation. And those who are here in the room, I think you know how it works. So, Ms. Marinos, my first question is for you. The bill, and it's not exactly about children, but there are provisions about femicide. And so I would like to ask your opinion as a jurist, what your opinion is on femicide. Thank you very much for your question. I will answer in English.
Sur le fémicide.
I'm not an expert on femicide.
I don't prosecute cases. I believe that this is an attempt to deal with a problem that we're facing across the country. We've seen so many femicides in Canada, too many. And it is an attempt to take the various provisions from,
Par exemple, je m'excuse, je vous
For example, I'm sorry to interrupt you, but I have to go quickly. So there is no definition of hate crime, but it could be included in the definition of femicide. But we can also see that there are a number of people who will fold femicide into any crime or against or any murder of a woman. But if it happens in a bank during a holdup, for example, but then if it's an intimate partner and there's a good insurance policy, well, then the purpose might be to get the insurance money, for example. But if you look at a femicide and what happened in Montreal and at the Polytechnical Institute a long time ago, I mean, there it is femicide. So what is the definition?
Would be a clear example in my mind, femicide. In other cases, maybe not as clear, but we heard from the witness, Ms. Cook. That's the kind of situation that we would be trying to avoid with these sorts of provisions, so that we don't get to that point.
Dites-moi, est-ce que
Please tell me, so when we define femicide, at the last sitting of the committee, we wanted to include women and girls because there is a distinction between the two. I haven't quite understood that distinction exactly. I'd like to hear more about that. But beyond that, a trans person who is born male and then transitions into a woman, should that person be considered a woman or a girl, depending, and include the crime against them in the category of femicide, do you think?
You're getting outside the ambit of my organization's expertise. We all have our personal views about that, but...
Okay. Merci, je comprends.
Yes, I understand. So I will broach another topic. So when it comes to harassment, with Bill C-16, do we want to define fear as something that is subjective? Well, do you think that's a good idea? So the person who is living in fear, who is being harassed or is being threatened with a crime, like killing their pet, for example, do we assess the fear of that person on an objective basis or a subjective basis? Is it a reasonable person should be fearful in such a situation, or should it be, regardless of what a reasonable person might fear or not, is the victim who is fearful? That what matters. What is your opinion on that?
I'd have to just look at the provision and see how exactly that provision is worded, if it's subjective or objective. I would think that it is you have to have a subjective fear.
OK, je comprends. Merci. Je vais pas...
Yes, I understand. Thank you. I'll go to a third topic, and I'm sorry, I know I'm going quickly, but I am taking advantage, like my colleague, I'm taking advantage of your expertise. And so when I ask about the Jordan considerations when there are trials that that don't take place within the right time. It's 18 months in provincial court and 30 months in federal courts, but it seems reasonable for a number of reasons that we won't go into today. But C-16 has some provisions to calculate time periods and to enable courts in some cases to give other consequences than just aborting the judicial process. So I'd like to hear your opinion on that. Do you think that's a good thing or not? And I might not be able to ask after this, so I'll ask now, because we're often told that if we give a tribunal or courts too much leeway to not respect the 18 months and the 30 months, then it'll give the impression that those time periods are not significant, and it'll sort of send the message that courts can more easily let time go by. What do you think?
To set up the parameters around those delays. We've seen delay be a huge issue in the justice system with stays of proceedings that are granted and victims who don't see accountability for crimes that have been committed. So I think that it's a good thing to set those limits.
Monsieur.
Thank you. Mr. Ulloch. Oh, I'm done? Done.
So we're going to start the second round, and we've got, it's a 5-minute round, so we're going to do one Conservative, one Liberal in the block, and then we're going to have to stop, and then we've got to pass our budget, and we'll be done by 6:30. So Mr. Lawton, you have 5 minutes, and you're starting now.
Thank you, Mr. Chair, and thank you, witnesses. I'd like to turn to the witnesses from the Ontario Child Sexual Exploitation Investigators Association. I'm not sure which of you would like to address it, but just to establish as a baseline, you view mandatory minimum sentences as having a very important role in the criminal justice system, correct?
Yes, we do.
And when we look at the way that we're trying to, hopefully, in the course of our work on Bill C-16, protect those, I just want to point out that in the Senville decision, which triggered this part of this, we actually saw at the lower court level a judge go below the mandatory minimum sentence and give an offender who had possessed hundreds of videos and images of children as young as, I believe, 4, a 90-day sentence. So just from your perspective, when we already had a mandatory minimum in place and that decision came down, how can we stop that moving forward?
Thank you for the question. Sorry, is the question like how do we stop judges from going below?
Yeah, because I know you and other investigators have seen judges disregard what I think a lot of people in society, and certainly a lot of the people who elect us, would expect of the justice system. And I'm just wondering what legal tools we can use to ensure that we actually have mandatory minimums that have teeth.
Yes, I think, the initial answer to that is that if a judge gives a ruling that goes against the law, then the remedy for that is for the Crown to appeal and to bring it up into an appellate court to enforce the mandatory minimum. My co-witness, Lisa Henderson, if you have anything to say on that as well.
Yes, for the benefit of the committee, I retired a few years ago, but I was a Crown attorney for 32 and a half years. And the last 20 years of my career, I was the Ontario's provincial lead for our provincial strategy to prevent internet crimes against children. I think that in many of the cases where the mandatory minimums were struck down by the courts, it was based on a theoretically at least reasonable hypothetical and not on the idea that the sentence imposed on the particular offender for the particular facts for which they were being sentenced was cruel and unusual punishment, but rather the defense counsel or the court would get creative in coming up with some idea of an example where a year mandatory minimum sentence would be inappropriate, strike down the minimum, and then feel like they could give a sentence below the minimum to an offender. I think that the way this bill is worded goes some distance to stopping that, in the sense that it tells the court that they can't come up with some hypothetical situation. They have to look at this particular offender and the facts of this particular case and determine whether or not that would be cruel and unusual.
So I don't think it will stop in the long term the overall problem of hypotheticals, but I understand your point, Ms. Henderson. And I guess I'll ask you, as a former Crown, do you believe that in virtually any case you were prosecuting in which there was a mandatory minimum in play, a defense lawyer would try to use this safety valve to argue against a mandatory minimum for their client?
My mother used to always say, how can someone argue that? And the simple answer is that people can argue anything. The question is whether a judge will buy it, and then whether an appeal court will uphold a judge for having accepted that argument. And I think that's where there will be litigation in the beginning, and then we'll get decisions from trial judges and from appellate courts, which will limit how that is applied. I can only tell you that when the mandatory minimums were brought in 2004, it saved us having to fight a lot about the appropriateness of conditional sentences for image-based or child sexual abuse offenders. And now here we are in 2026, and we're fighting this exact same issues we were fighting in 2004.
I only have a short time left. I don't have any questions for you at this time, Ms. Cook, but I just wanted to thank you for being here, first and foremost, and for sharing what you did. We cannot talk about law and laws in the abstract without hearing about the very real people affected by them. And your testimony that you shared is a very real part of our consideration on this bill. And I just want you to know, and I think I speak for all members of this committee, how appreciative we are and how much we admire your courage in speaking about something that I know is very fresh. So with that, thank you.
Thank you, Mr. Lawton. Ms. Latanzio.
Thank you, Mr. Chair. And I also would like to thank you, Ms. Cook, for bringing forward your story and sharing that with us. And with Bill C-16, we hope that it will address most of the issues that you brought forward today. I also want to thank Ms. Marinos for being present, but my questions, Mr. Chair, will be directed to both Mr. Ulloch and Ms. Anderson. So, Mr. Ulloch, investigators have long faced challenges when certain online platforms argued that they were not captured by the Mandatory Reporting Act. Would you agree that clarifying that all online services, including social media and app-based platform, are covered and will close a major loophole and materially improve your ability to identify offenders?
Thank you for the question. And yes, we do, because as you said, it takes away the question. It takes away the ability to say that we didn't think it applied to us. The obligation to report once they find and once they discover material on their platforms, that's a very large source of our investigations in Canada. And so when when all of the internet service providers are compelled to report on that, then that increases the likelihood that we're going to investigate and then catch someone, which has that deterrent effect. Ms. Henderson also has some experience in dealing with mandatory reporting. If you could speak on that as well.
Yes, in fact, the only convictions that I'm aware of under the Mandatory Reporting Act were for individuals that I prosecuted. They all pled guilty and were sentenced to different things with respect to that. But I think part of the problem is it's always hard to prove a negative. So in order to prove that somebody failed to report is difficult, but I think the obligation existing and it being much more clear to whom the obligation applies should go some distance in ensuring that people do make the reports, and hopefully then we won't have to have any more prosecutions for people who fail to do so.
Now, you often deal with complex investigation that take months and not days. So under the current 21-day preservation period, how often is critical evidence lost? And would extending that to 1 year significantly improve your ability to build cases and, more importantly, secure convictions?
In a lot of other types of investigations, 21 days is relatively a decent amount of time. However, in child exploitation cases, that's actually very short, especially when you consider that evidence and reports have to go through multiple hands before it lands in the jurisdiction. Because one of the challenges is figuring out where a report has to go, right? Because the internet is something that doesn't have boundaries. So a Canadian entity may have to report on it, but that doesn't mean the offender or the suspect is in Canada. So there is an administrative process that has to be undertaken simply to figure out what jurisdiction it needs to land on. So it passes through multiple hands, and each hand has its own backlog. So by the time it finds its way to an investigator's desk, it can be well beyond 21 days. Can be well beyond 30 days. Sometimes it's several months, and if all of the evidence has been purged before it even gets to an investigator, then the investigation never gets started. So definitely extending that preservation time to be 12 months would absolutely help.
Reports can be sent to different police services, which can create delays and fragmentation. Would you agree that centralizing reporting to a designating law enforcement body, such as the National Coordination Center, for example, would streamline investigations and lead to faster, more effective responses?
I would agree that that would work so long as it is properly staffed and resourced. You get an advantage in that you have one entity handling everything, and that's good. But if it's not properly staffed and resourced, then you only have that becomes a shortcoming. You only have one entity to handle all of it, and then so that's where you get backlogs and things like that, and that's where investigators will get their files a lot later. So as long as it's adequately staffed, then that would definitely simplify things.
If I can add
Yeah.
one thing there. I also think additionally right now the Mandatory Reporting Act requires people to report to a police service, but it doesn't say which one. And so in order to prove that somebody didn't do that, it becomes a bit overwhelming to prove that they didn't report to any police agency. If it were in fact only one, then it would only be one place you would have to check to see if in fact a report had been made. So I agree with Andrew that it has to be staffed appropriately so that things don't sit there and they do get passed on to the relevant police agency. But in terms of from the prosecution side of it, being able to prove that a report wasn't made, it would certainly simplify that.
Thank you to you both. Thank you, Ms. Latanzio. And last word to you, Mr. Fortin, for 2.5 minutes.
Monsieur le Président.
Thank you, Chair. Ms. Cook, I have a question for you. In your presentation earlier, you talked about some expert evidence that you wanted to provide to the court, and you said it was refused. So I was wondering whether you could tell me about it, what kind of expertise, and what happened, and why was it rejected?
Thank you for that question. So unfortunately, and I think I'm not a legal expert, but I think the therapeutic records kind of touches on this. And because there is a lot of overlap in coercive control cases where family courts are involved, criminal courts are involved, being able to use the information through these support services and the professionals who staff them and support victims would help the justice system generally to assess the risk level that's actually existing.
Okay. Mais est-ce que vous avez eu un problème avec...
Yes, but did you have a problem with a particular report from a doctor or from a social worker or a psychologist?
Et si je comprends bien, le problème...
And if I understand correctly, the problem was with trying to use this report in the various instances, right?
Yes, and it starts right at the beginning with reporting to police, even before it gets to a court. So, for example, when I applied for the police peace bond, of course, I had interactions with police prior, but I wasn't allowed to show that pattern to an individual officer. It was their discretion, and therefore that wouldn't go into court should that officer in interviewing me not see it necessary to include.
Je comprends. Merci, Madame Cook.
Yes, I understand. Thank you, Madam Cook. Thank you, Chair.
Thank you, Mr. Fortin. Okay, that concludes all our questions. I just want to say Thank you to all of our witnesses for taking the time to be here. And let me add my thanks to you, Ms. Cook, for sharing your personal experiences. I know how difficult that is, and it's very meaningful to the committee, so I really appreciate it. So I'll get the witnesses. You're free to go. Thank you. Last bit of business is we do have the budget request or budget approval for this study. Everybody's received a copy. I'd just like to get it approved. Total amount of the budget is $46,600. Of that, $40,600 is for witness expenses, $2,500 for headsets, and the balance is for meeting-related sundries and whatnot. We have approval of the budget? All in favor? Yes, yes, yes? Okay. Budget approved. There we go. Thank you. Okay. He's been asking me to do that for 3 meetings, so. Okay. He threatened to cut off the food if we didn't pass it today, so. Anyway, okay. Thank you very much, everybody. Meeting adjourned.
Sorry, I talked.